Hey everyone, there is a long-awaited update in the Elderwood/Three-Frog Hex Box case. This is the hexagonal-shaped dice box that Elderwood Games or Three Frog LLC are selling with 7 hexagonal holes in a hexagonal-shaped box, which they claimed trademark rights to. They also claimed copyrights, but that was denied, as you'll see in this trademark filing. This case involves ongoing litigation in which I'm one of the attorneys representing Mr. Taylor, the opposer. So I'm going to focus on the facts of what the Trademark Trials and Appeals Board has ruled. Quick note, because this is trademark litigation, while we do have a plaintiff and a defendant, we really call it the applicant, which is Three Frog or Elderwood, the trademark applicant, and there is Chris Taylor, the opposer, who opposes the granting of the trademark application. This case has been ongoing for a while, since about 2+ years ago. Mr. Taylor contacted me shortly after I made a video about the trademark application, and then I started a GoFundMe on his behalf to raise funds for his opposition. We finally filed the opposition in early 2020, went through some discovery and depositions in late 2020 and early 2021, and then Elderwood/Three Frog filed their motion for summary judgment on July 28th, 2021. And after some back and forth through September of 2021, we finally got a ruling on February 28th, just a few days ago. So without further ado, here is that ruling. This is a ruling by the Trademark Trial and Appeals Board, February 28th, Chris W. Taylor Jr. versus Three Frog LLC. This proceeding is before the board for consideration of applicants' July 28, 2021 motion for summary judgment and motion to dismiss, as well as opposers' cross motions for summary judgment. On September 20th, 2018, applicant filed a trademark application for use of an applied for mark in commerce to register the following trademark. You can see here it is a hexagonal shaped box with 7 hexagonal holes in it to hold dice for gaming. The application identifies the following international class 28 goods. Dice boxes, namely boxes specifically adapted for storing dice. Wooden boxes specifically adapted for storing board game components or dice. Board game and tabletop game accessories, namely accessories in the nature of boxes specifically adapted for storing board game components or dice, and includes the following description of the mark. The mark consists of a 3-dimensional configuration of the interior of a hex-shaped box with a honeycomb configuration of 7 interior hexagonal indentations on the bottom of the box and the design of a 6-point star having flat points on the top of the box. The broken lines depicting circular magnets indicate placement of the mark on the goods and are not part of the mark. The applied for mark was refused registration as a non-distinctive product design. Trademarks are given different levels of protection based on how distinctive they are. Applicant filed a response asserting a claim of acquired distinctiveness, that a low distinctiveness design has acquired distinctiveness after being sold in commerce and customers learn to recognize that design, is the claim. The examining attorney issued a final refusal, in response to which applicants submitted additional evidence. The application was approved with the acquired distinctiveness claim. This opposition followed. Opposers' operative pleading sets forth the following claims. Count 1, that the applied for mark is functional. Functional items should not be trademarked. You'll see more about that later. Count 2, non-distinctive trade dress lacking acquired distinctiveness, that the mark has not actually acquired the distinctiveness required for a low distinctiveness mark to be recognized as a trademark. And 3, that no bona fide use of the applied for mark in commerce has been made. Trademarks must be used in commerce, so the claim was that the mark has not been used in commerce. Applicant moved for summary judgment with respect to 1, opposer's entitlement or standing, and 2, non-use, arguing that applicant, was using the applied for mark as of September 20th, 2018. Applicant included a motion to dismiss the functionality count in the second amended notice of opposition for failure to state a claim upon which relief can be granted. In response, opposer included a cross motion for summary judgment with respect to entitlement or standing. It included a cross motion for summary judgment on non-distinctive trade dress, lacking acquired distinctiveness, count 2, and did not contest the non-use portion, and did contest the motion to dismiss the functionality count. Thus, on this record, the following are presented for consideration by the TTAB. 1. Cross motions for summary judgment on opposer's entitlement or standing to bring or maintain a cause of action. 2. Opposer's cross motion for summary judgment on count 2, non-distinctive trade dress lacking acquired distinctiveness. 3. Applicant's motion for summary judgment on count 3, non-use. And 4. Applicant's motion to dismiss count 1 functionality in the second amended pleading for failure to state a claim. This is a summary judgment motion. Summary judgment is only appropriate where the movant, the moving party, in this case both parties moved for summary judgment, demonstrates that there is no genuine dispute as to any material fact, and that it is entitled to a judgment, a final judgment as a matter of law. A factual dispute is genuine if, on the evidence, a reasonable fact finder, like a jury or the TTAB in this case, could resolve the matter in favor of the opposing or non-moving party. So if there is a genuine dispute of a fact that's important or material or germane to the dispute, then that needs to go to trial for the fact finder to weigh the evidence, weigh the credibility of witnesses, and then make a decision. If there is a genuine dispute, then summary judgment will not be granted. The board may not resolve genuine disputes as to material facts. It may only ascertain whether genuine disputes as to material facts exist. On the first issue, opposer's entitlement or standing, you have to have standing in order to bring a case. So if opposer does not have standing or entitlement, then the whole case is over. The U.S. Supreme Court in Lexmark International versus Static Control Components, Inc. established 2 requirements for determining whether a party has an entitlement. Consistent therewith, applicant must demonstrate that there is no genuine dispute, that opposer cannot establish 1, an interest falling within the zone of interests protected by the statute, and 2, damage that is proximately caused by the prospective registration of the mark. Demonstrating a real interest in opposing registration satisfies the zone of interest requirement. Demonstrating a reasonable belief in damages by the prospective registration satisfies the second requirement. A plaintiff does not have to prove its claims or demonstrate actual damage to establish entitlement. Relevant to his entitlement, opposer alleges. So these are things that Mr. Taylor said in his opposition. Applicant's registration of a functional product design harms both opposer and the consuming public at large because it would confer an unfair monopoly upon applicant to which it is not entitled under law. Opposer designs and sells dice boxes. Opposer sells his products through various online channels, including on social media and e-commerce sites like Thingiverse. That's a spelling error. Thingiverse is the proper spelling. Opposer's dice box includes exactly 7 spaces for each of the dice in a Dungeons & Dragons set, and each space is in the shape of a hexagon in order to accommodate the D20 die, which has a cross section. It's a hexagon, regardless of which space the player places the die. The configuration of the hexagonal tessellation, such as that depicted in Opposer's dice box, is the most efficient way to arrange the 7 dice slots within a singular container. Opposer has been designing and fashioning these types of hexagon tessellation-shaped dice boxes for literally decades. Opposer began crafting his hexagonal tessellation-shaped boxes back in the mid-1990s after seeing a similar box used as a model in a woodworking class. This third-party box, which Opposer used as his model, was, in turn, made several years prior to the time Opposer began crafting his own boxes. Opposer then began selling his boxes casually to customers upon request, for which he charged a modest sum to compensate Opposer for his time and materials. Originally, Opposer crafted his boxes from wood. Over time, Opposer began crafting boxes from wood-filled PLA, a composite of plastic and wood fibers, due to the material's popularity with customers. Later still, Opposer began developing his boxes using 3D printing. Knowing that the functional aspects of his boxes are common within the D&D universe, Opposer has never sought trademark or copyright protection for the general shape and configuration of his boxes, and was not aware of any other maker or seller seeking such a monopoly prior to being notified of applicants' filing. On August 23, 2018, applicant applied to register a copyright. So within his opposition, one of the arguments against Elderwood/Three Frogs trademark registration was that even the U.S. Copyright Office had denied a copyright on this design. Trademark is a separate office, a separate agency, and a separate set of intellectual property rules, but one of the arguments was that they applied for copyright and they were denied. According to the Copyright Office file history for the Hex Chest copyright application, the application was refused registration on October 24, 2018 on the basis that the applied for design was a useful article that does not contain any copyrightable authorship needed to sustain a claim to copyright. On June 22, 2020, the U.S. Copyright Office issued a final ruling upholding its refusal to register a copyright in the Hex Chest box. On January 16, 2019, Opposer received a notification from Thingiverse that his listings had been removed in response to a complaint filed by applicant under the Digital Millennium Copyright Act. This complaint was filed on behalf of Quentin Weir and alleged that Opposer's Thingiverse listings infringe on our sculptural copyright of our Hex Chest dice boxes. Applicant's complaint asserted both trademark and copyright ownership of the hexagonal tessellation depicted in both Opposer's boxes and its own, despite the fact that applicant had no issued trademark registration and no issued copyright registration. Opposer filed a counter notice under the DMCA on January 17, 2019, pointing out that applicant did not, in fact, possess rights in trademark or copyright, and that his listings were removed in error. Thingiverse immediately reinstated Opposer's product listings. Then, Opposer received notice from Thingiverse that his listings were again being suspended, this time based on a complaint brought by applicant under Thingiverse's other IP rights violation policy. Once again, applicant asserted proprietary rights to the hexagonal configuration of Opposer's dice boxes based on its filing of the trademark application, which applicant falsely characterized as granted. Opposer submitted another counter-notice to Thingiverse, again stating that applicant did not possess statutory rights in either copyright or trademark. Thingiverse again reinstated Opposer's sales listing on their platform. Opposer learned of applicant's trademark filing and applicant's further attempts to gain an unfair monopoly on hexagonal tessellation-shaped dice boxes. Opposer also learned from his review of industry comments that Opposer, or rather applicant, was targeting other sellers of similar box designs with its bogus claims of exclusive ownership of the hexagon tessellation box design. Fearing that he and others would continue to be targeted by applicants' anti-competitive bullying, Opposer filed this notice of opposition. Back to the TTAB ruling, applicant argues, among other things, that Opposer has no commercial interest in preventing applicant's registration, that Opposer is not in the business of selling dice boxes, has not applied to register a trademark, and did not create the 3D print file for the hexagonal dice box that was the original basis for applicant's copyright complaint to Thingiverse. Applicant argues that Opposer is an intermeddler who appointed himself to police the trademark register, trying to prevent applicant from registering its trade dress because Opposer did not believe the application was legally registrable. Regarding Opposer's reasonable belief in damage, applicant adds that Opposer does not sell products that are similar to applicant's dice boxes, that the only dice boxes Opposer has distributed were those he gave away for free at festivals, that Opposer's posting to and removal from Thingiverse was a digital file with a copyright claim, not an actual dice box, that Opposer posted the file because he has an axe to grind, and that removal of the 3D print file for the dice box had no impact on Opposer's income. In support, applicant points to Opposer's deposition. Opposer argues that he makes videos about 3D printing and uploads various CAD files to the Thingiverse website, which individuals download to enable them to print various objects using 3D printers, and that his files include ones for making a hexagonal box to hold objects including dice. He submitted his declaration stating that he has designed and printed hexagonal boxes, wants to distribute files that others can use to 3D print these boxes, and wants to distribute and sell the boxes he prints. Opposer argues he came within the zone of interest when applicant sent its DMCA notice to take down files for the dice box, and that applicant's notice both falsely alleged that it had copyright and trade dress protection and expressly referred to this trademark application. Regarding proximate damage, Opposer argues that he incurred injury by way of the DMCA takedown request. He submitted a copy of the January 14, 2019 DMCA takedown request and the ensuing correspondence that applicant's principal, Quentin Weir, sent. The notice states that Opposer's dice box files posted on Thingiverse violate applicant's rights in the trade dress of the dice box. We find that neither party has met the high burden to establish that there is no genuine dispute of material fact with respect to Opposer's entitlement to bring a statutory cause of action. At a minimum, regarding Opposer's real interest in opposing registration, Opposer has offered testimony in his declaration that on summary judgment, it is sufficient to show that he has a commercial interest in preventing applicants' registration inasmuch as it would preclude Opposer from uploading design files that include, feature, or are arguably similar to the applied for mark depicting the applied for box, the exclusive right to which would be granted to applicant if it were issued the registration. Regarding Opposer's reasonable belief in damage, we find that he has come forward with evidence and a declaration based on first-hand knowledge that lead us to find a genuine dispute as to a potential injury to Opposer's interests in distributing to consumers his files of information on how to make hexagonal dice boxes and in selling the boxes that he makes in the event that applicant were to secure a registration for the hexagonal dice box product design. Thus, the issue of whether Opposer can prove his entitlement remains an issue for resolution at trial. In view of these findings, applicant's motion for summary judgment and Opposer's cross motion are denied, which means the issue of Opposer's entitlement or standing is going to be adjudicated at a trial before the Trademark Trial and Appeals Board. On to summary judgment for count 2, non-distinctive trade dress lacking acquired distinctiveness. To prevail on summary judgment, Opposer must demonstrate that there is no genuine dispute of material fact that applicant has not established in its application that its non-distinctive trade dress has now acquired the distinctiveness in the minds of the purchasing public, such that its applied for mark distinguishes its goods from those of others. That was a complicated way of saying that customers recognize the product even though the trademark is sort of light or low on the distinctiveness scale, that customers recognize the product and therefore the applicant should get the trademark on that. Opposer maintains, among other things, that the evidence before the examining attorney consisted of several pro forma declarations, declarations that are all the same form, that are all either identical or very similar. You know, instead of one person saying, I know this, and the other person saying, I know that, both of them say basically the exact same thing, pretty much in the exact same words. The pro forma declarations contained the same typographical errors, including no evidence that the declarants were consumers of the boxes, did not provide specifics as to how many people visited applicants' convention booths or purchased the goods, did not include evidence of how applicants' goods were presented to consumers, and did not include any consumer perceptions such as in surveys. Applicant argues, among other things, that its supporting declarations are from persons with knowledge of the dice box and tabletop gaming industry. It also points to its assertions and evidence in its application regarding volume of sales, length of use, its Kickstarter campaigns which led to sales, its advertising, and its coverage of its goods in media. We find that Opposer has not met its burden to demonstrate that there is no genuine dispute of material fact. On the issue of acquired distinctiveness, no single evidentiary factor is determinative. The value of each type of evidence, the amount that is necessary, varies and depends on the nature of the mark and the circumstances surrounding use. Here, at a minimum, the record shows that there are genuine disputes regarding the material fact of whether the amount and type of applicant's evidence is sufficient to establish that applicant's dice box applied for mark has acquired distinctiveness in the minds of the purchasing public. The parties dispute the weight and probative value to be afforded to portions of the application record evidence, including, for example, the declarations on which applicant relied in examination. In view of these findings, Opposer's motion for summary judgment on count 2, the non-distinctive trade dress lacking acquired distinctiveness, is denied. So that issue will also be going forward to a trial before the Trademark Trial and Appeals Board. On count 3, non-use, applicant maintains that it has sold its dice boxes embodying the applied for mark continuously since 2014. They offered testimony, the Kickstarter campaign raising $60,000, testified to sales figures, submitted a declaration of counsel, including posts of its hexbox design on Imgur and Reddit, etc. Opposer did not oppose, and therefore summary judgment is granted, which means that the issue of non-use is now settled and will not be going forward to a trademark trial before the TTAB. Finally, applicants motion to dismiss the functionality count. We find that Opposer sufficiently pleads a claim that the applied for mark is functional. Opposer alleges the product design depicted in the application contains several key features which are merely functional or aesthetically functional, including A, the use of exactly 7 slots to hold 7 dice used for D&D, and B, hexagonal-shaped slots to accommodate the D20 and other polygonal dice used in D&D play, and C, an overall configuration of 7 hexagonal-shaped slots that form a hexagonal tessellation. Opposer alleges with adequate clarity that the applied for mark, the 3-dimensional configuration of a hex-shaped box, includes elements that are essential to the use or purpose of the product. Boxes specifically adapted for storing board game components or dice. Opposer provides fair notice of the claim that the applied for mark is a functional design. See the Traffics Devices versus Marketing Displays case. A feature is functional as a matter of law if it is essential to the use or purpose of the product or it affects the cost or quality of the product. The Traffics Devices case is an often cited trademark case, which stands for the principle that functional items cannot be trademarked. In that case, applicant had filed for trademark protection on the springs on the bottom of their roadwork sign. The springs helped the sign sway in the wind without falling over, and were deemed functional and therefore not trademarkable. In view of the finding that Opposer sufficiently pleads a claim of functionality, applicant's motion to dismiss count 1 for failure to state a claim is denied. Consequently, this proceeding includes in count 1 a claim that the applied for mark is functional. So to be clear, the TTAB did not find that the hex box is functional, but rather that Opposer sufficiently pleads the claim and that it can go forward to a trial before the TTAB. In summary, at the appropriate time to be determined and set forth by the board in a future order, this opposition shall proceed with respect to Opposer's entitlement to bring a statutory cause of action, count 1, functionality, and count 2, non-distinctive trade dress lacking acquired distinctiveness. In the event that the board resumes proceedings, the board may reset dates as appropriate so as to provide applicant an opportunity to file its answer to and take discovery on count 1, functionality. Pursuant to Trademark Rule 2.117a, whenever it shall come to the attention of the TTAB that a party or parties to a pending case are engaged in a civil action or another proceeding which may have a bearing on this case, proceedings before the board may be suspended until termination of the other board proceeding or civil action. In its brief, Opposer included a copy of the complaint filed in Three Frog LLC doing business as Elderwood Academy versus Metallic Dice Games and Adam Hackett, an individual, in which applicant filed against the third party on July 1st, 2020 in the United States District Court for the Eastern District of Michigan. The board must ascertain whether suspension of this opposition proceeding is appropriate in view of this civil action. To that end, applicant is allowed 20 days from this order to file a submission informing the board whether any claims or counterclaims in that civil action involve this applied for mark, and if so, a copy of the pleadings that set forth the claims and defenses that involve the applied for mark, the status of the case, and if the case has been finally determined, and a copy of the final order if issued. Meanwhile, this proceeding remains suspended. Proceedings remain suspended pending the submission of the required information regarding the civil action. Taking a quick look at that case, it appears that that case was dismissed in September of 2020, so it shouldn't actually suspend proceedings for that long. So yeah, it looks like the Hex box case, which is Chris Taylor opposing the trademark application of Three Frog / Elderwood Academy, it looks like it's going to trial. I'm going to refrain from any further commentary because there is ongoing litigation, and I will update you when I have another ruling to bring to you. If you want to support Mr. Taylor, who has incurred attorney's fees to get here, you can do so at the GoFundMe link in the description below. Thank you to all of the supporters who have made it possible for Mr. Taylor to bring this opposition against Three Frog / Elderwood Academy's trademark application. Let me know what you think in the comments below. And that's today's video. Special thanks to my top supporters in March: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, The Blood-Soaked Survivors, and Wyatt Calandro. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.